Hello everyone, welcome back to UPSC Tribe. My name is Teja. In this video, we will be discussing about the salient features of the Indian Constitution today. First of all, every country has its own constitution. Likewise, our India has its own constitution. Today in this lecture, we will see the prominent features of our constitution. First of all, let's understand what does the word constitution mean. I will read out the statement first, then I will break down the statement and explain. Constitution is a document with a special legal sanctity that provides a framework according to which a country shall be administered. It provides for three principal organs of the state and principles according to which they should function. The Constitution is basically a document or a book with a special legal sanctity. That means it is the highest book, or it is the supreme book which has rules to govern this country. It has a framework, which means a structure in which a country should be functioned. It provides for three principal organs. We all know the three principal organs are legislature, executive and judiciary, and principles according to which those three organs should function. Simply put, it is a supreme book, or it is the utmost superior law of the country. We all know the Constitution. We often listen to words like articles, clauses, or parts often while reading polity. Let's try to understand those terms. The word articles are, simply put, they are provisions in the book. Let's say they are a set of rules that are present in the Constitution. Clauses, the articles are further divided into clauses, and clauses are further deeply divided into subclasses. Let's say we have an article 1. In that article 1, we have clauses 1, clauses 2. Also, those clauses are further divided into, the first clause is further divided into subclauses like 1A, 1B, and further. Let's understand the word parts. Articles of similar nature, which are of have similar duties, they are grouped into parts, and we also have schedules. At the end of the book, these schedules are appendices or attachments. Let's say they are tables or other forms that are attached at the end of the book. I hope this suffices. The Constitution of India is unique in its content and spirit. We have most of the provisions borrowed from other constitutions of the other countries of the world, but our Indian Constitution is unique in its letter and spirit. Article 368 of the Indian Constitution provides for the feature of amendment from time to time. By the prevailing circumstances and necessities, we have amended our Constitution so many times. The basic structure doctrine is laid down by the Kesavananda Bharati case in 1973. Later in our lectures, we will record a special session regarding the landmark cases in the Indian polity. For now, the basic structure doctrine is propounded by the Honorable Supreme Court of India Constitutional Bench in the Kesavananda Bharati case 1973. The matters in the basic structure doctrine cannot be amended by the Parliament even through the constitutional amendment process. It is a solid structure. Now let us look into the salient features of the Indian Constitution. The first salient feature, that is the prominent feature, is lengthiest written constitution. Often constitutions are classified into written and unwritten constitutions, whereas the written constitution is an American constitution, the unwritten constitution is the Britain constitution. The Constitution of India is the lengthiest written constitution of all the constitutions existing in the world. While framing the Constitution, originally there were 395 articles, 22 parts, and 8 schedules. At present, the number has changed. There are 12 schedules 25 parts, and we have already surpassed around 470 articles. We have 470 plus articles right now. The reason for this lengthiest written constitution is the geographical factors and diversity. India is a vast land that has a longest geographical extent, largest geographical extent, and there is a huge diversity in that exists in people in this subcontinent. We often call India a subcontinent. The historical factors like the Government of India Act 1935 in specific, we have obtained most of the provisions in the Indian Constitution from the Government of 1935, Government of India 1935 Act. So the reason for the lengthiest written constitution is the Government of India Act 1935. We have the single constitution in India, be it at the center of the state. The India has the single constitution. Unlike the other countries like America, it has its own constitution, and also further states will have its own constitution. The Constituent Assembly is dominated by the legal luminaries like Dr. B.R. Ambedkar, who himself is a lawyer, and other members of the constitution are also the legal luminaries. Our constitution not only has the fundamental principles but also administrative provisions. We don't simply say that there is only simple fundamental principles, but also we have administrative provisions like the functioning of the Election Commission, or let's say CAG, or other organizations of importance. We all know that the Constitution of India is drawn from various sources. There is a famous saying by Dr. B.R. Ambedkar. The Indian Constitution is ransacking of all the constitutions of the world. Dr. Ambedkar opined in such a manner. The word ransacking here means, let's simply put, it is kind of stealing. We have obtained or adopted so many provisions from the other constitutions of the world. In this table we have here it is a detailed table. When you look at the table, there is a lot of provisions that have been borrowed from the other constitutions or other countries. For example, the fundamental rights, which are favorite topic to everyone, is borrowed from American Constitution. The directive principles of state policy are borrowed from Irish Constitution. The 5-year plans and fundamental duties are borrowed from Soviet Constitution. The office of the governor and federal structure of the Indian Constitution is borrowed from the Government of India Act 1935. Go through this table, you will know what provisions are borrowed from which constitutions of the country. This table is of paramount importance because you may get a question, be it in your UPSC or other state public service commissions or SSC, asking to match the pairs. Let's say the examiner will give British Constitution and mention as judicial system, and he will ask to identify different pairs. There is a greater scope for confusion. So I will ask students to by heart this so that you will always remember this. You will never forget this. Now let us go to the third salient feature, the blend of rigidity and flexibility. The constitutions are often classified as rigid and flexible constitutions, but India has a blend of it. Let's deeply look into the terms rigidity and flexibility. Something rigid is that cannot be easily amended. Something flexible is that can be simply amended by a simple procedure. Let's say rigid is the special procedure for amendment. We need special procedures for amendment. The American Constitution is a rigid constitution. Flexible, the British Constitution is a simple and flexible constitution because it can be easily amended. The provisions in the Constitution can be easily amended when we have a need and necessity to amend it. The Article 368 in the Indian Constitution provides for the reasons for the blend of this rigidity and flexibility. From Article 368, it is evident that we are a mixture of rigid and flexibility. Our constitution is rigid and flexible because some provisions in the constitution need to be amended by the special majority. That means 2/3 of the members present and voting in both the houses of the parliament, and also by the majority of the members present. And the second provision talks about some provisions can be amended by the special majority by ratification of the half of the states. See, the half of the states in the Indian Union should agree for such amendment. It becomes so much rigid, and some provisions can be simply amended like the ordinary law. To amend an ordinary law, it is so much flexible, but to amend some provisions in the constitution, it needs a special majority, and also special majority with the ratification of the half of the states. So this is why we call our constitution as the blend of rigidity and flexibility. The fourth feature is federal system with unitary bias. We are a federal system, there is no doubt, but there is a unitary bias. That means the constitution leans towards the unitary principles. We have India. Sir Ivor Jennings opined that India is a federation with a centralizing tendency. There is no doubt there is a separation of division of powers between the center and the states, but also there is a slightly centralizing tendency in the constitution. There are some provisions in the constitution that proves we are federal system. The two governments, both at the center and the state, we have a written constitution, the supremacy of the constitution, rigidity, bicameralism. That means we have both houses, Lok Sabha and Rajya Sabha, and independent judiciary proves for the federal system. The independent judiciaries, we have Supreme Court at the highest level and the high courts coming to the states, and subordinate courts and district courts are further in the following hierarchy. The union features are, there is a strong center, we have only single center and a single constitution and also a single citizenship. Likewise in the US, they have two citizenships. First, a citizen of the United States of America, and also he will become the citizen of a state there. A US citizen has two citizenships, whereas in India, we have only single citizenship. He is the Indian citizen. He or she will be the Indian citizen. There is a flexibility of the constitution, and also there are emergency provisions. During the emergency provisions, all the powers that are vested in the state governments are automatically transferred to the central government. There is a slightly unitary bias in the Indian constitution. And also the word federation. Students, you should keep this word in mind. We are not a federation. That means we have not formed as a state by the fact or by the matter of agreement. USA, the states combinedly agreed to form a country, but India is not like that. We are always single. That means we are always functioned as a whole. India as a whole become a nation. We were never divided. The Article 1, there is no mentioning of the word federation. Article 1, India, that is Bharat, is the union of states. We are a union, not a federation. Sir K.C. Weir opined that is, we are quasi-federal. Quasi in the sense we are semi-federal. Now let us look into the fifth feature of the Indian Constitution. Parliamentary form of government. We all know that India is the parliamentary form of government. It functions on the principles of cooperation and coordination. The cooperation and coordination both between the legislature and the executive forms a parliamentary form of government. India is also called as this form of government in particular is called as the Westminster model of government, because we have adopted this parliamentary form of constitution from the British Constitution. Westminster is a place in London where the British Parliament is located, whereas the United States form of government is the presidential system of government. In the parliamentary form of government, we will have nominal and real executives present, the president and the prime minister. In the parliamentary form of government, we have the majority party rule, where a party which gets a majority of seats in the Lok Sabha or vice in the same manner in the state legislature will form the government. There is a collective responsibility of the council of ministers. They are collectively responsible to answer the houses or the parliament. The membership of ministers in legislature. Let's say a legislature, to become the minister, the membership of ministers in legislature is simply put like a member is the member of the house first, then is also the minister in the same house. So a minister has both the membership in the legislature as well as in the cabinet. The leadership of the PM or CM. The leader of the house in the parliament is the prime minister, whereas in the state assemblies is the chief minister. The parliamentary form of government provides for the provision of the dissolution of the lower house. If the members decide and put no confidence motion, the Lok Sabha can be dissolved by the members agreeing to it. It is also called as the prime ministerial government because the dominance and presence of the prime minister in taking the majority of the decisions as the leader of the house and as the leader of the government. It is called as the prime ministerial government. Now, let us look into the sixth provision, the synthesis of parliamentary sovereignty and the judicial supremacy. Synthesis is the mixture of parliamentary sovereignty and judicial supremacy. The parliamentary sovereignty concept is adopted from the British it is present in the British Parliament, and the judicial supremacy is part of the American Constitution. The American Supreme Court is supreme in its country, and whereas the Parliament in Britain is so strong. In India, we have a strong parliament and also the independent judiciary. So we have synthesis of both parliamentary sovereignty and judicial supremacy. The Supreme Court scope is narrower in India when compared to US. I have already said that American Supreme Court has a wider scope in judicial matters than when compared to Indian judiciary. We have a concept called as due process of law versus procedure established by law. Some luminaries opined that India has also turned itself into the due process of law, but I think the Constitution has provided for only the process established by the law or the procedure established by the law. Let's understand the differences between the due process of law. The due process of law is present in the United States of America, whereas the procedure established by law is in the India. The due process of law has a wider scope. The wider scope is given to the judiciary, whereas in the procedure established by law in India, the scope of judiciary is narrower when we compare it to USA. In the due process of law, the Supreme Court can overdo the laws of the Parliament, whereas in the Indian perspective, let's say for a offense, the Parliament has decided that a 5 years of jail sentence. When the court trialing such cases, the only 5 years offense principle will come into rule, because it is the procedure established by the Parliament. When framing a law, they have explicitly mentioned for offense X, the punishment is 5 years. When it comes to trial to the court sees the law that has already been made by the Parliament, and while trial, it awards the 5 months jail sentence to the accused. It is the due process of law versus the procedure established by law. I hope you understood this very well. Supreme Court declares parliamentary laws unconstitutional. There is also a greater provision given the independence of the judiciary in our country. The Supreme Court has when a law crosses the line of the fundamental rights, the Supreme Court of the country or the highest court of this country, or it can be the High Court also, can declare a law as void. If it infringes the fundamental rights of citizen, the law can be declared void both by the Supreme Court and High Court by the process of judicial review. Article 368 provides, we have already discussed, to amend the major portion of the Constitution. So, from this, both the provisions of the judicial review and also the amendment procedure mentioned in the Article 368, we can say there is a synthesis of parliamentary sovereignty and judicial supremacy in the Indian Constitution. The seventh feature is integrated and independent judiciary. India has an independent judiciary, well functioning. The Supreme Court as the highest court at the center, and also when coming to the states, the High Courts, and High Courts has the district courts, and district courts has the subordinate courts in the country. There is a clear-cut hierarchy and mentioning of these courts in the Constitution. The independence of judiciary can be understood from this feature. The expenses of the judiciary are charged on the Consolidated Fund of India. These are only charged, that means these matters can be put in the parliament for discussion, but they cannot be put for voting. It guarantees the independence of the judiciary without impacting the functioning of the judges in the court. Also, the judiciary has the greatest power to draw contempt, to punish for contempt, be it criminal or civil contempt. This High Court at the state and the Supreme Court at the center can draw contempt proceedings if anyone disobeys the orders of the courts. This feature provides for the independence because the conduct of the judges cannot be discussed in the parliament or in the state legislature. The conduct of the judges only can be discussed if there is a removal notice given or there is a procedure established to remove the judge of the Supreme Court or High Court. Only on such circumstances the conduct of judges can be put. There is a ban on practice after retirement on the Supreme Court and High Court judges. Once they are banned, they cannot practice further. The aspirant's favorite topic, fundamental rights. The fundamental rights, we all know, they are adopted from the Constitution of the United States of America. They are enshrined in the Part 3 and has mentioning from Article 12 to Article 35 in the Indian Constitution. The fundamental rights envisages the idea of political democracy in the country. They help to identify or they aid in the functioning of the political democracy in this country. These fundamental rights are put as the limitations on the state. It protects the interests of the citizens by limiting the actions of the state. The fundamental rights are there to protect the citizen from the limitations of the state. The Constitution of India provides for the writs. In Article 32, we have 5 writs: habeas corpus, certiorari, mandamus, prohibition, and other writs that are mentioned in the Article 32. When the fundamental rights of a citizen is infringed, the citizen can directly go to the Supreme Court or High Court to restore his rights. Students must note, sometimes people argue they have right to freedom of speech and expression while giving their opinions. But we often forget the right to freedom of expression is a fundamental right firstly. Then fundamental rights are not absolute. They have reasonable restriction. The state can reasonably restrict by giving reasons in the interest of the security of the state to protect the order in the country. Some fundamental rights can be restricted. They are not absolute, friends. The fundamental rights are suspended during the national emergency. Only Article 20 and 21, the Article 21 is right to life and Article 20 is retrospective effect of the law. That is, Article 20 states that if a person has committed an offense previously when it was not an offense, he cannot be charged for it. The acts committed before by the person cannot be framed as charges if the law later names it as an offense. The Article 20 says it protects the citizen. Now let us look into the directive principles of state policy. Dr. B.R. Ambedkar called the directive principles of state policy as a novel feature of the Indian Constitution. They are enshrined in the Part 4 of the Constitution. They promote the social and economic democracy. These are principles that are given by the Constitution and constitutional makers to the governments. While any law is framed, the Constitution explicitly advises the governments to look into DPSPs and to make laws inconsistent with the directive principles of the state policy, because these directive principles aims at the social and economic democracy, whereas the fundamental rights aims at the political democracy. The directive principles of state policy aims at the social and economic democracy. The directive principles of state policy aims for a welfare state, whereas the fundamental rights protects the interest of the citizens from the state. The directive principles of state policy aims for a welfare state. There is no legal obligation on directive principles of state policy, whereas the fundamental rights has it. The directive principles of state policy has only the moral obligation. We all know that fundamental rights are enforceable by the law, but whereas the directive principles of state policies, DPSPs, are not enforceable by law. There is a famous case called Minerva Mills case. While discussing the landmark judgments, we will deeply discuss, but for time's sake and for now, let's say in Minerva Mills case, the Supreme Court has opined that there is a fine balance between the fundamental rights and DPSP in the Constitution. The Indian Constitution is founded on the bedrock of the balance between the fundamental rights and the directive principles. The Honorable Supreme Court has opined during the Minerva Mills case of 1980. Now let us see the 10th feature, that is fundamental duties. These fundamental duties are inserted in Part 4A, Article 51A. While the original Constitution was framed, the constitutional makers has not given space for these fundamental duties. They were later added. Likewise, the directive principles of state policy, these are non-justiciable in nature. That means these cannot be challenged in any court. These fundamental duties were added by the 42nd Constitutional Amendment Act of 1976. This is the famous Constitutional Amendment Act. When there is a mentioning of any amendment, students must note such amendments. There is a greater chance of asking these amendments in your examination. When I say amendments, you please write. There is a need to by heart, so that you will not get confused in the examination. Later you can revise this if you write now. The 42nd Constitutional Amendment Act 1976 is also called as the mini constitution, because many of the things were amended by using this 42nd Amendment Act. The Swaran Singh Committee has recommended for the addition of the fundamental duties in the Constitution. The 86th Constitutional Amendment Act 2002 added one fundamental duty. There are altogether 11 fundamental duties in the Constitution right now. Originally, the Swaran Singh Committee recommended 10 and 10 were added. Now there are 11. These fundamental duties, as I have said, these are not justiciable in any courts. This fundamental duties serves as a reminder to all the citizens in the country while enjoying the fundamental rights that are guaranteed by the Constitution of India. It is the moral duty of the citizen to also look into the fundamental duties to promote the spirit of common brotherhood. Now we have the 11th feature. This is an interesting feature, I know. The secular state. The word secular was later inserted in the Constitution through the 42nd Amendment Act of 1976, the mini constitution. We will later, in the coming points, will understand what does a secular state in the Indian context means. Article 14, 15, 16, 25, 27, 28, 29, 30 and 44 proves that India is a secular state. Article 14, where gives the right to equality. Article 15, that there is no citizen should be discriminated on basis of religion. Article 30 gives for the minorities to establish educational institutions, and Article 44 is UCC. These articles in the Constitution of India says that India is a secular state. They are points of evidence. The Western secularism versus Indian secularism. Interesting points. The Western secularism, in the Western countries, the church is separated from the governance. The meaning of secularism is different there in the Western countries. It has a negative meaning. There is a clear separation. There is an indication or a clear separation can be seen between the church and the government. Whereas in India, there is a positive secularism. Secularism in Indian context is very different. In India, we have no official religion, but the government encourages and protects all the religions equally. So this is, in Indian context, there is a beautiful aspect in India. But we doesn't discriminate any religion. The government protects and encourages all the religions. The Indian secularism is a positive secularism. To further prove, there used to be the communal representation, that means reservation of seats basing on the religion. That provision was abolished. Now that provision doesn't exist. Universal adult franchise. Every citizen not less than 18 years of age, to give the representation to every citizen who crosses 18 years of age. The constitutional makers have done a beautiful experiment. First it was 21 years, later it was reduced to 18 years. We will look into it. The right to vote as a constitutional guarantee, as a constitutional element, was existing in the Indian Constitution. Every citizen not less than 18 years of age has the right to vote to elect its own representative. It provides there is no discrimination on basis of caste, race, religion, sex, wealth, literacy, to give equal chance to vote, to protect and uphold the self-respect of the masses in this country. The constitutional makers did a beautiful experiment, giving the voting right without discrimination. The 61 Constitutional Amendment Act 1988 further reduced the age from 21 years to 18 years. Aspirants must note this. This may be asked in the examination. In compliance with the 61 CA 1988, 61st Constitutional Amendment Act 1988. The universal adult franchise upholds the principle of equality because it guarantees right to vote to everyone. The interests of the minorities are enhanced because there is no discrimination. Even minority or majority, whoever it is, whoever crosses 18 years of age can exercise his right to vote. The 13th feature is single citizenship. I have already said that we have India as only single citizenship. If you ever take the citizenship of another country, automatically your Indian citizenship will get cancelled. Because India, like in the United States of America, as I have earlier said, the citizen is the citizen of the country than the citizen of the state. There are two citizenships. Dual citizenship is present in other countries, whereas in Indian context, we have only single citizenship, my friends. Every citizen enjoys equal rights regardless of the state, because as a citizen of India, I represent myself as a citizen of India, not a citizen of any other state. So I have an equal right to enjoy. I have already discussed the USA context of dual citizenship. Now the 14th feature is independent bodies. The Constitution of India provided for the Indian independent bodies as part of the administrative provisions I have earlier mentioned. We have Election Commission of India mentioned in part 15 of the Indian Constitution. Article 324 to 329 deals with the Election Commission in the Constitution of India. The Election Commission, to conduct free and fair elections in the country, an independent body has been put. I always say this, it is the Election Commission of India, not the Election Commission Government of India. Election Commission of India is an independent body that draws its powers from the Constitution of India, not from the central or the state governments in the country. We have the Comptroller and Auditor General of India. The Comptroller and Auditor General of India is the guardian of the finance purse in this country. The CAG examines and audits the accounts of the state and the central government for the propriety. There is also UPSC, Union Public Service Commission, and State Public Service Commissions. Both the UPSC functioning at the center and the State Public Service Commissions functioning at the state level to conduct the examinations for the recruitment of the All India services and also the state cadre services in the state. 15th feature is emergency provisions. To protect the sovereignty, unity and integrity and security of the country, the Constitution gives the provision of emergency. Whenever there is a threat for the sovereignty, unity, integrity and security of the country, the emergency provisions are invoked to protect our own selves. The emergency provisions are enshrined in the Constitution to protect the political system and the constitutional mechanism or the machinery in the state. When these emergency provisions are implemented, all the powers are diverted to the center. The state has no say in the governing rules. The center has all the powers while the emergency provisions are invoked. While the emergency provisions are in order, the Indian system turns from federal to unitary. Normal times, it is federal in nature, slightly biased, but to the unitary side. But when the moment emergency provisions are invoked, all the federal powers are transferred to the center. It becomes a unitary state. We have said sovereignty, unity, integrity and security, but we have not discussed the meaning, my friends. I know you will have a doubt. We always keep saying it, but we never examine or look towards the meaning of such things. There's a chance UPSC might ask such things also. Let's look into the meaning of sovereignty, unity and integrity. Sovereignty means supreme or independent authority of state over its geography. India has its own geographical extent. The supreme and independent authority over such geography only vests with my own country or India, friends. The other country has no say. We are independent and we have say on our own land. This is the principle of sovereignty. Unity. Unity is Venus or oneness. It is an emotional or psychological term. There is oneness among the individuals in the country psychologically and politically. Integrity. What does integrity mean? It looks similar to the unity, but whereas in unity it is the emotional thing, in integrity it is a territorial or geographical thing. Integrity refers to the geographical wholeness. The country has a single geographical entity or the country as a whole in respect to geography. The Indian territory is indivisible or indestructible. So, whereas the unity is psychological or political or emotional feeling, whereas the integrity is related to geographical or territorial relation. Part 18 in the Indian Constitution is related to emergency provisions. We have three types of emergencies in India: national emergency, state emergency or president rule, or the financial emergency. Let us look into the national emergency. Article 352 in the Indian Constitution deals with the national emergency. During the times of war or external aggression or armed rebellion, the central government invokes Article 352 and declares a national emergency to protect the integrity, sovereignty, and unity and security of the country. Article 356 deals with the state emergency, or this is also called as President's rule, friends. When there is the failure of the constitutional machinery in the state, or if a state is non-compliant with the directions of the center, the state emergency can be invoked by the Article 356 of the Indian Constitution. When there is a financial instability that is going, there is a huge pressure on the exchequer of the government. Article 360 is invoked to protect the country from falling. The financial instability often comes at times to protect the country's interest. The financial emergency is invoked by the way of Article 360, friends. Let's look into the 16th feature, three-tier government. Originally there was only mention for the dual polity or bicameralism, the center and the state, but later three-tier government system was made. Article 73rd Constitutional Amendment Act 1992 was made. Panchayats were added into Part 9 and Schedule 11. You must remember, 73rd Constitutional Amendment Act 1992 is related to Panchayats, whereas the 74th Constitutional Amendment Act 1992 is related to municipalities. 73 and 74 made in the same year, 1992. 73 is related to Panchayats, whereas 74 is related to municipalities. The Panchayats come first, so 73. The municipalities are the newer versions, so 74. It were made later, 74. Made at the same time, but for the matter of understanding, for the sake of understanding, I am reading it out in a different manner. The 73rd Constitutional Amendment 1992 this is in regard to the Panchayats. 74th Constitutional Amendment Act 1992 is related to municipalities, friends. Part 9 is 73rd Constitutional Amendment Act. Part 9A is related to municipalities in the 74th Constitutional Amendment Act. Schedule 11 is related to Panchayats. Schedule 12 is related to municipalities. Please note this down. This may be confusing. This is also previously asked in questions. So 73rd, let's read it out again. Three-tier government. Originally there were only center and state. The third tier is formed by the way of 73rd and 74 constitutional amendments in the year 1992, whereas the 73rd Constitutional Amendment Act provides for the Panchayats. It is mentioned in the Part 9, Schedule 11. Clear? The 74th Constitutional Amendment Act was made in the year 1992. In the same year, it is related to municipalities or the urban local bodies, Part 9A and Schedule 12. Urban local bodies or municipalities is similar, and the panchayats are rural bodies. Now we have cooperative societies. Sahakar se Samriddhi. This is nice, badhiya slogan. 17th is the cooperative societies. What is cooperative societies? Let's first try to understand. Cooperative societies are self-help groups. They are not supported by the government. They are supported by the members in that group. So it is called as self-help groups, SHGs. Self-help groups where members voluntarily pool resources for mutual benefit. I said there is no interference from the external entity, state government or any other authority. There is no interference. Cooperative societies has its own say, friends. These are self-help groups where members voluntarily join. They pool resources for the mutual benefit. It is for the benefit of everyone. We have Amul as an example, the best example. It is the grassroots of economic democracy. Yes, these are mostly established with the rural entities. Sahakar se Samriddhi is the slogan. Development with cooperation. Let's say Sahakar is cooperation, Samriddhi is growth. The 97th CAA 2011, 97th Constitutional Amendment Act 2011 gave constitutional status to the cooperative societies. Remember this 97th Constitutional Amendment Act. We have discussed so many Constitutional Amendment Acts. These are often asked in the examination. There is a greater chance of further asking these questions in the upcoming examinations too, friends. So please make a note of it. The cooperative societies constitutional bodies? Yes, they are constitutional bodies. It got constitutional status from the 97th Constitutional Amendment Act in the year 2011. Article 19, it is a fundamental right, gives the right to form cooperative societies. Everyone has the right to form cooperative societies voluntarily. Article 19 guarantees it. It is a fundamental right. Article 43B, this is the DPSP, Directive Principle of State Policies. It recommends the state for the promotion of the cooperative societies. I have already said DPSPs are advisories to the state. So DPSPs ask for the promotion of the cooperative societies. Part 9B, the cooperative societies was inserted in the Part 9B. Remember these things, friends. The cooperative societies has a mention in the Part 9B. Article 243H, ZH and Article 243ZT are related to the cooperative societies. Oh, now we have the criticism of the Constitution. First criticism, I have already said Dr. B.R. Ambedkar opined that the Indian Constitution is ransacking of all the constitutions in the world. It is the stealing. The Indian Constitution is made by stealing all the constitution in the world. Let's say, be it fundamental rights, directive principle of state policy, the division of powers, federal powers, be it the 5-year plans we have adopted from the Soviet Union, also from the Japan, we have adopted from most of the famous countries we have adopted most of the provisions. The carbon copy of the 1935 Act. I said majority of the provisions in the Indian constitutions are adopted from the 1935 Act. It is also called as the carbon copy of the 1935 Act because both in substance and in language it looks similar to the 1935 Act, friends. And also some critics said that the Constitution of India is un-Indian. It reminds me of the statement of the Constitution member, the K. Hanumataya, said that we wanted the music of Veena or Sitar, which is related to Indian context. We wanted the music of Veena or Sitar, but here we have the music of the English band. That means the slavish provisions that were adopted from the British Parliament or British Constitution is being pointed out here. You can write it you can quote this thing in the your answer mains answer writing. When you write your mains answer, we wanted the music of Veena or Sitar, but here we have the music of English band. Beautifully said, friends. It is said by the member of the Constituent Assembly, K.V. Hanumataya. Elephantine size. Friends, we have the emblem of the Constituent Assembly is elephant. Some members opined that in consonance, in similarity to the title or the emblem we have, the Constitution is of the elephantine size because of the both administrative and other provisions and other government functioning principles. It has become of greater and larger size, so it is often called as the elephantine size constitution. It is criticized for being such big in size. This is the paradise of lawyers. Sir Ivor Jennings opined that it is the paradise of lawyers because the constitution has the greatest influence of from its members, because Dr. B.R. Ambedkar, who is the chairman of the drafting committee, is himself is an advocate. So the impact can be clearly seen. There is also presence of the great members or the legal luminaries in great extent in the Constituent Assembly. So Sir Ivor Jennings called this as the paradise of lawyers. Now let us look into the PYQs, my dear friends. I will read out this question first, later we will solve it. First I will read out the question, then we will solve it, right? Okay, let's choose a color, right? First question. The distribution of powers between center and state in the Indian Constitution is based on the scheme provided in the Minto-Morley reforms, option A. Option B, Montagu-Chelmsford Act 1919, Government of India Act 1935, Indian Independence Act 1947. Easy question. Let's solve this question by reading out again. The distribution of powers. This question talks about the distribution of powers. Sorry, my bad. This question talks about the distribution of powers between the center and the state in the Indian Constitution is based on the scheme provided in. It is obviously the Government of India Act 1935, friends. The answer is C. I have already said that most of the provisions are borrowed both in content and spirit from the 1935 Act. It looks similar. The critics has also called it as the carbon copy of the Indian Constitution as the Government of India Act 1935. The distribution of powers between the center and state, the federal principles, are borrowed from the Government of India Act 1935. Let's look into the second question. I hope you got it. Consider the following pairs. There's no scope for elimination. We have to consider everything. Indian secularism, Article 14, 15. Okay. Voting age, second pair. Voting age is reduced to 18 from 21 by the 61st Amendment Act of 1988. Okay, looks good. Option 3. Single citizenship. Indian Constitution provides for single citizenship. Fourth statement, Election Commission. Part 15 of the Constitution. Okay. Right? This looks great. Now let us do it. I have already told while dealing with the secularism topic, Article 14, 15 is the evidence that Indian Constitution, India is a secular country. Article 14 says that gives right to equality. Article 15 says that no citizen is discriminated based on religion. So Article 14 or 15 are related to Indian secularism, right? This is correct. Voting age reduced to 18 from 21 by the 61st Amendment Act of 1980. Yes, we have discussed this point also. The voting age was originally in the universal adult franchise topic. We have said that voting age was originally 21. By the 61st Amendment Act of 1988, it was further reduced to 18. It was originally 21, it was further reduced to 18 by the 61st Amendment Act of 1988. Yes, the amendment is correct, here is also correct. The second statement is also correct. Single citizenship. Yes, absolutely. India has the provision for the single citizenship. The Indian Constitution provides for the single citizenship. Yes, this statement is also right. Election Commission. Part 15 of the Indian Constitution. Yes, I have told that Article 324 to 329 were present in the Part 15 of the Indian Constitution. Yes, this is also right. We have discussed all these points. Thank God. So now option is all four pairs are correct. Option C. Option C is correct. Now let us discuss the next question. Which of the following is not a feature of the Indian federalism? Right? This is asked in the 2017 prelims. Which of the following is not a feature of the Indian federalism? First statement, there is an independent judiciary in India. Option B, powers have been clearly divided between the center and the state. The federating units have given unequal representation in the Rajya Sabha. Okay. It is the result of an agreement among the federating units. See, every statement looks right and of similar nature that is related to Indian federalism. Let's read it out again and identify. Which of the following is not? The question asks not. You should always, when you see the word not in your question paper, students, please underline it. You may overlook in the exam confusion or the exam stress. When you look at the word not, underline. Which one of the following is not a feature of the Indian federalism? Okay. There is an independent judiciary in India, right? We said that there is the Supreme Court at the center, and at the state level we have High Court. Yes, this is right. Powers have been clearly divided between the center and the state. Yes, India is a federation. Powers are clearly divided between the center and the state. Yes, this statement is also true. The federating units, that means states, federating units as states, have been unequal representation in the Rajya Sabha. Yes, and Rajya Sabha is called as Council of States. Every state does not have similar representation. It has this separate formula for calculation. So there is an unequal representation. This statement is also right. The federating units have been given unequal representation in the Rajya Sabha. This statement is also right. Now comes the option D. Only option left. It is the result of an agreement among the federating units. I told you, friends, India is not formed due to the agreement like the USA. USA is formed as a federation because of the agreement between the states. But India is not formed. India is whole always. There is a wholeness in its territorial existence. So this statement is wrong. It is not the result of agreement among the federating units. So this statement is wrong. So the correct option is option D. Next question. Which of the following in Indian polity is an essential feature that indicates that it is federal in character? UPSC has a greater interest in the term federalism. There are frequently questions asked from this topic, so you must pay attention to it. Anyhow, we will discuss this in greater length in coming chapters. So let us read this question. Which one of the following in Indian polity is an essential feature that indicates that it is the federal in character? Essential feature. The independence of the judiciary safeguarded is Union legislature has elected representative from constituent units. The Union cabinet can have elected representatives from regional parties. Yes. The fundamental rights are enforceable by courts of law. Every statement looks right. But we have been asked to identify the essential feature. The independent judiciary is safeguarded. The essential feature of federalism is always related to the separation of powers between the center and the state. Although the first statement looks correct, but it is asked about the essential feature. The Union legislature has elected representatives from the constituent units, friends. Yes, constituent units are the constituencies that are located in the states. So this is the critical feature related to the federal in character. So we'll select option B. Option B is the correct answer. Option C and option D are also correct, but option B is more prominent and suitable to the question asked. So let us see this option C also, because there is a greater chance of confusion by the aspirants. The Union cabinet can have elected representatives from regional parties. Yes. The Union government can also take the ministers from the regional parties. Friends, to become a minister, he must be a member of any of the house of the parliament, be it Rajya Sabha or Lok Sabha. Or even if he is not a member, after 6 months he can become a member. Prior to that 6 months he can be also taken as a minister into the cabinet. So this doesn't become an impediment even from the regional party or not. This is not the criteria. Now let us look into the next question. Which of the following statements are correct about the Constitution of India? Oh, looks interesting. Powers of municipalities are given in the Part 9A of the Constitution. Yes, I have told this. Powers of municipalities are given in the Part 9A of the Constitution. Let us look into it, friends, where I have discussed it. See, I have told you, Part 9A is related to municipalities and Part 9 is related to panchayats. The same statement has come. So you must be careful. Powers of municipalities are given in the Part 9A of the Constitution. Yes. Part 9A is correct. Part 9 is related to municipalities, rural local bodies. Part 9 is related to urban local bodies and municipalities. This statement is correct. Emergency provisions are given in the Part 18 of the Constitution. Yes, absolute. We have also discussed this point. Part 18 mentions the emergency provisions. 52, 56. Provisions related to the amendment of the Constitution are given in the Part 20 of the Constitution. Yeah, Article 368 deals with the amendment of the Constitution. We have not discussed, I think, but this Part 20 is correct, friends. You must look into it. Part 20 deals with the amendment of the Constitution, that is Article 368. I think we have not discussed it, but you take a note of it. This is asked in the UPSC 2024 prelims. All the things are correct. So all the statements are correct. 1, 2, 3. There's no wrong ones this time. Everything is right. We have a mains practice question. I hope you guys will do it. This is an easy question. The Indian Constitution is often described as a unique blend of rigidity and flexibility. Critically evaluate this statement with examples. Excellent question. We have discussed this in the class today. This question talks about the Indian Constitution is described as a unique blend of rigidity and flexibility. I have told you, we are a mixture of rigidity and flexibility. Article 368, while amending the Constitution, we have special majority with the ratification of half of the states and the special majority. We have unique blend of rigidity and flexibility. When it's come to flexibility, we have ordinary laws can be simply amended. We are both Britain and we are American when it comes to amendment of the Constitution. So we are blend, we are union, or we are mixture of rigidity and flexibility. Critically evaluate this statement with examples. You can write it with the examples of United States of America and Great Britain. I hope you will write this answer. Thank you guys. Thanks for listening so patiently. Let's call it a day. I hope you enjoyed this lecture. Stay tuned for more classes. Thank you. Jai Hind.